Pigia Bwana Yesu makofi. Ni wa neema Yesu, ni wa neema kubwa.
Yesu ni wa neema kubwa.
Ni wa neema Yesu, 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 ni wa neema kubwa.
Yesu, ni wa neema kubwa.
Ni wa neema Yesu, ni wa neema kubwa.
Mungu wetu ni wa neema kubwa.
Ni wa neema Yesu, 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 ni wa neema kubwa.
Ni wa matei Yesu, ni wa matei manene.
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 Ni wa matei Yesu, ni wa matei manene. Ni wa matei Yesu, ni wa matei manene. Ni wa neema Yesu, ni wa neema kubwa.
Makofi kama unaamini ni neema. Nimepata Mungu wangu, nimepata Baba.
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 Ninakuatia ngai wakwa, ninakuatia tata.
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 Ninakuatia ngai wakwa, ninakuatia tata. Ninakuatia ngai wakwa, ninakuatia tata.
Nimepata Mungu wangu, nimepata Baba. Amen. Mimi ni baba yangu, sijui wewe ni aje. Tukiwa tu tumesimama so that we bring our speaker on stage. I would like you to know that the lady who is coming is older in this ministry than many of us, because she has worked with Bishop ever since the days of Redeemed Gospel Church. So ametembea na askofu muda mrefu. She is the chair of this church. Mumeenda huku nyuma mkaona Cathedral? Mnaona vile iko kubwa? Vile iko smart? She's the engine behind the construction of that church. Amen. Amen. She's an advocate of the High Court, a practicing lawyer. Amewahi kuwa magistrate. Sijui kama aliambia watu wanyongwe. I don't know about her sentences atatuambia. But she's here. She graciously agreed to come and kutufundisha mambo ya sheria. Kwa sababu ni vizuri tujue. Unajua kunena tu kwa ndimi peke yake, ukishikwa haitakusaidia. Kunena tu kwa ndimi peke yake wakati anko amechukua shamba yenu, hautaenda kwa anko unene na ndimi. Itabidi uangalie mambo kisheria. Wakati hao waume wetu tunaombea, kuna wakati kunaenda vile kunaenda, tunaomba ndio, lakini inabidi sheria ichukue mkondo wake. So atakuja atufundishe wakati tunahitaji sheria. Ndio kuomba, of course kuomba naye hatuwezi kosa kuomba, but kuna wakati lazima sheria itumike. Kwa hivyo ninakualika sana ma'am, let us put our hands together as we invite our lady C.P.M. Ndungu. Amen. Amen. Hallelujah. Amen. Amen.
Oh, praise God. Niko na homa lakini nimeshindwa. I don't know where to start. But thank you, Pastor Florence and Bishop. Thank you, my chair lady. Thank you, the committee that organized this. Thank you, the pastors' wives. Thank you, all of you. And Jane, nimebarikiwa. We are favored. So after all that, I don't know whether we should now go to law. But in a bid, like, and mine is to read, so I will not move, I will just read. I'm told we can't understand English. You know, it's written in English, so I don't know. Well, I'll need my sister to translate. To translate? Okay, thank you. Okay, kindly sit.
Tafadhali tuketi.
I've been asked to discuss family law.
Nimeambiwa kuongelea mambo ya kifamilia.
So I'll walk you through the children's law.
Sasa nitawafunza kuhusu mambo ya watoto,
matrimonial property,
mambo ya mali ya ndoa,
and then a bit of divorce and a bit of succession.
Kidogo mambo ya divorce, mambo ya talaka. Amen.
And I appreciate that we don't have to go through this, but we'll help somebody out there.
Na ni vyema tumepewa nafasi hii maana mtu atasaidika.
Okay, starting with my names. My names are Patricia Muthoni Dongo.
Jina lake ni jinsi amesema.
Nimeokoka.
She's saved.
And I love God.
Na anampenda Mungu.
And as my share said, I've worked with Bishop since I was in my 30s.
Na jinsi mama alisema ametembea na Bishop tangia miaka za nyuma.
And now I'm in my 60s.
Na saizi ako 60s. Amen.
I have seen this altar speak into my life.
Ameona altar ikizungumza juu ya maisha yake.
And I thank you, Mom, Pastor Florence.
Asante mama.
I thank Pastor Jane for reminding us to honor our pastors.
Anashukuru sana mchungaji Jane kwa kutukumbusha kumheshimu mama.
Let us go to children's. The children are the future of any society, the church and the family, and they must be protected.
Watoto ndio maono ya kila familia na inafaa watunzwe.
When I look at the book of Psalms 127, 3-5,
kitabu cha Zaburi 127,
I'm reminded that children are a heritage of the Lord.
Inatukumbusha kwamba watoto ni wanapeanwa na Mungu.
So it's very important that we respect them and we take care of them.
Ni vizuri kuwaheshimu na kuwatunza.
So a child is defined as an individual who has not attained the age of 18.
Mtoto ni yule ambayo hajafika kiwango cha miaka 18.
And the Children's Act of the year 2022 gives effect to Article 53 of the Constitution.
Wow.
Haya. Mumeelewa?
Amen.
Sawa sawa. Si niendelee?
Amen.
But not in Kiswahili. Can I go on in English? Yes. Beautiful.
Thank you.
Okay. Thank you so much. Let us try. You ask questions and my sister, the share lady, atajibu in Kiswahili. So the Constitution and the Children's Act 2022 makes provision for children's rights, parental responsibility, guardianship, foster care placement, adoption, guardianship. The Act also makes provision for care and protection, and when children are in conflict with the law, the regulations of administration of children's services. So to speak something. So the Act deals with all that. So if you look at it's a big document. If you look at it, it gives all this. So when a child has a case, there is a care and protection. When a child has been defiled, when there is anything that deals with the child, we do it under the children. So even the children's homes, they are also governed by the same. It is important to point out that the rights and best interest of the child are safeguarded by the Constitution and many other laws. There are other outside laws. They also govern this. And no actions concerning the children, anything that concerns the children, the best interest of that child is primary consideration. So anything that happens, a child has been arrested, laundering, a child has stolen, the best interest of the child is taken care of, and that's where you find that children are not put in the cells together with adults. Upon a breakup, this is where I want us to cover, it is important to consider who is to stay with the child. Again, we are still protecting the child. So parties may approach a children's officer. There are children's officers in every sub-county who hears the two of you, and after mediating, they can also decide who will then take care of the primary care, that is what we call the custody, and who will then be having access to the child, who will be providing for that child. So parties may also approach an advocate to prepare what we call a parental responsibility agreement. So we don't have to always go to court. This is normally used when parties, that is parents, are not married. So if you are not married and you have a child with that person, instead of taking them, embarrassing them in court, and dragging the wives, it's good to do a parental responsibility agreement. The parental responsibility agreement is in the nature of parenting plan. So it plans how they will jointly make decisions on matters relating to their respective parental responsibilities. They also decide on contact information, visitation schedule, holiday and school break, transport, and travel within and outside the country, responsibilities for health and health care. They notify each other in case of change of residence, and the joint and several responsibilities, expenses of extracurricular activities, birthdays, holidays, etc. When this document is signed, what I have called a parental responsibility agreement, once it's signed by the two of you, the two parties, the two parents, it is filed in court, and court will always adopt it as a judgment of the court. So you don't have to go now through the court case. It also deals with each parent's responsibility to provide the child's basic needs, and it normally covers the period until tertiary education. So it's a very important document. You don't just deal with baby class all the way. You can deal with all the way up to when the child finishes school. And the courts will honor that. Should parties not agree on going to the children's officer or doing a PRI, the parental responsibility agreement, then we go to court. And what we need to go to court, the issue of parental, the issue of paternity is very important. You don't just drag any man to court. They will ask for a DNA test. And it will be embarrassing if you drag them and they are not the father. You also need a birth certificate. Again, children cases, proceedings maintain privacy of the child. In fact, when you file these cases, you say you are filing as a next friend. And if you have been to those cases, you find we use initials. We don't put the name of the child. So most of these cases are done in private, even what we call in camera. So you can request the court. Although courts these days hear us virtually, you can always ask to drop to court and hear. Or even the court can just remove everybody else, and you are heard only you, the father, and the children are not dragged into court unless they are of age, and the court would like to ask them questions. So sometimes you find the children may be requested to be produced. A parent or a guardian, so who can institute, may institute the proceedings to enforce a children's fundamental rights. Why we are doing this is to enforce the child's fundamental rights. And since a child cannot contract or consent, someone responsible, the next friend now, you the parent or the guardian, a grandmother, somebody has to come to court on their behalf. So that parent takes responsibility regarding their physical, financial, and spiritual needs, and know their needs. And I've just said that the filing of the case is by way of next friend for the minor. During the conflict, parents will need to continue with life, and someone has to make a decision on the children. You have disagreed with the father of the child, but there is need for the child's rights to be taken care of. So here we go to, there is a what we call legal custody. Both of you, as long as you are the parents, you both have the legal right to make key decisions on the children's education, life, and religion. There is also what we call actual or physical custody. This is the primary care, who is giving that primary care. And that's the person we say has actual control, care, and of the child. There is also joint custody. These days, after they amended the Children's Act 2022, November, any parent can have primary custody. You'll note that the law has changed to the extent that if the child is not breastfeeding, the father can have the actual custody. So in this case, children's rights to be with both parents is considered paramount, and it is important for the children to board with both parents, in which case parties agree on joint custody and access. So you'll find when you are co-parenting, you share the time. You'll find that you have each an alternate weekend, or you share the holiday into two and all the other public holidays. So before the year 2022, children of tender years, that is below 10, would go to the mother. Girls would go to the mother and boys to the father. But these days, this new act does not allow separation of the children. And I said unless the child is breastfeeding up to 1 year, the father can have custody. So shared custody, sometimes one parent stays, I've said, they divide time. So that's also very important. And to do this, most of the courts, even when we file cases, we do not have to wait until we are heard in court. Most courts screen, we call it screening for mediation. I did not say I'm a qualified mediator, I'm a professional mediator and accredited to the courts. So what the courts will do, they'll pass cases to us. So I have quite a number of cases from Mombasa, everywhere, as long as you're an accredited mediator. And by the way, my bishop is a mediator, if you didn't know. He is also a mediator. And it's important, those counselors, all of us, mediation is the way to go. When you have issues at home, when you have issues in the society, they will trust you to mediate over the issues they have. So children matters are heard without delay, as delay is prejudicial to the children's welfare. So you find we have a designated children's court where only children matters are heard, and they are fast. Not 30 days. Mediation goes for 60 days at most, but children cases go up to 60 days. Like now when it's near going back to school, and somebody has not been paying school fees, you are supposed to go in good time so that the court can determine who is going to pay that school fees and the rest. I'll tackle that. Courts will also listen to experts. So they will normally have what we call a children officers report. So these children officers, you see, they are very important. They come visit your home, the father's home. They ask questions to both of you and the children if they are of age, and they make a report. And courts will use that report in making a final decision. A guardian or a parent may apply. Sometimes parents may be so careless, reckless, that a show or another guardian may have to apply for custody. So it is important before making the application. My experience, I said I am 40 years in that work. I'm 40 years in legal practice. So what I have seen, of course the law has changed over the years, like 4 times since I became a lawyer in 1985. But what is important is that before you make this application in court for custody, you better have the child with you. If you make the application when the child is not with you, then you have to do an application for the child to be produced. It's also, but it's tedious. So take control of the child. So in determining whether or not a custody order should be made, courts will have regard to the conduct and wishes of the parents or the guardian, the ascertainable wishes of the relative of the child, the ascertainable wishes of the child, whether the child has suffered harm or is likely to suffer harm in the hands of the other parent. That parent cannot have custody. The customs of the community to which the child belongs. I know there are communities here where the father is the primary caregiver. They don't allow their children to walk away with you. So that's a difference. So we'll look at the customs of that. The religious persuasion of the child. If the child, you've brought them up in Cathedral of Praise, where Christ is the Lord, then in Imara, a Muslim, that child will have to remain with you because that's the religious persuasion. The circumstances of any sibling of the child. Court will not allow us to separate children. So they will want our children to stay together. And of course, the best interest of the child. And the Act has defined the best interest of the child to be the age, maturity, and stage of development, the gender, the background of the child, the distinct needs of the child, like chronic ailment or disability. So the preference of the child, children can be asked to choose whom they want to stay with when they are of age. Normally, age 9, kuendelea. Duration and adequacy of the child's current living arrangement. So when the social officer comes and finds your house is in that disarray, they will write it down. You lose that custody. So what kind of living arrangements do you have? Do you share your bed with the children, boy child? Do you share your bed? Does your child share the bed with house helps? So those ones are very important, the living arrangements that you keep for the child. The court will also want the continuity. If a child has been living with you for 3 years, the court will not want to disrupt that, so you may have custody. The child's adjustment to the present home, school, and community. So if a child is attending a school next door here, so court will not allow the child to be pushed to Nyeri, for example. So the parent who is nearby, or both of you then have to get a residence nearby. There is also the willingness of the parent to cooperate and resolve disputes concerning the child, and the capacity of that parent to cooperate. So if the parent is kishwangumu, they may have to lose custody. So the existence of domestic abuse between the parents may push your children to a home. And in our 80s and 90s practice, judges would say children, if you disagreed and you disagree over who is going to take care of the child, you'll find those judges pushing children to Bernardo. When there is a history of the child abuse by either parent, that is also very important to check in. And I said where the child is under 1 year. And if a parent has been convicted of a sexual offense or is living with one who has been convicted, they cannot get that custody. That's so much for custody. Let me go to maintenance. So a child will need custody. That is the care, the care of that child. Where does she sleep, eat, and all that? Then maintenance is now the financial. It's the joint duty and responsibility of both parents to maintain the child, whether those parents are married or not. I think that's the question my chair lady had asked. What happens to that father who is not taking care because you got a child with him and he was married, or got a child that did not marry you? You have a right to follow him to maintain the child. Bola too, the DNA will not give a different story. A parent or guardian may apply for maintenance. And a person who has this one rule, only people up to 18 years, I call them children, but there is an exception to that rule, that even if your son or your daughter has reached age 18 and the father is not maintaining, and they still require to go to school, and they are suffering from a illness or other special circumstances, or they require medical care beyond the 18th birthday, courts will extend their maintenance for that child. So there's need to, and I need to say that it doesn't matter whether there are matrimonial proceedings. Matrimonial proceedings are separation and divorces. A maintenance order will still be made. So the court is guided by the following consideration: the income or earning capacity, property and financial resources which the parties have, the financial needs and obligations or responsibilities which each party has, the financial needs of the child's income, physical or mental disability, illness, and chronic diseases. You find that there are cases where if a child needs extra care, the courts will also take into account that. The manner in which the child is being or was expected to be educated. You cannot have your child in a particular school, and then when there is a separation, the child has to move to a public school. So courts will also look at that. And so what happens when one does not, so what is the maintenance for? The maintenance is to provide the child with basic needs. And our basic needs includes basic nutrition and food, water and sanitation facilities, clothing, medical care, including immunization, basic education, general guidance, social conduct, and moral values. And so that's the basic needs. So what happens if a court has made an order for maintenance and you fail to honor? The court will then, the person who is in what we call a decree holder, the person in favor of, in whose favor the order was made, may move the court to attach the salary of that person, which is up to 1/3 of the salary. All may ask the court to commit them to civil jail. There is a whole procedure. All attach their property. There's a whole procedure which we call notice to show cause. So that person is called to show cause why they should not be committed to civil jail, why their salary should not be attached for failing to take care of their children. Other areas that are covered in the Children's Act will be guardianship and adoption. So when you need any of these areas that concern children, then it's good to approach your advocate. It's also important to say, what about where the person is deceased? You can still access, through the succession court, you can still access maintenance of that child, even if it's only through the succession. So you become an administrator in that course, and then you are able to have your child also taken care of. Because in times of passing on, you find most of the family members, they may block you even from accessing the money that was in the bank. And remember, that money immediately that person passes on, it's frozen. So you need to move the succession court under an urgent application to get an interim, what we call an interim grant. It's just a representation document that allows you then to access. So you'll need all the documents, the school fees structure, you need the school fee structure, you need to summarize a schedule of how much money you need for this maintenance thing, because you need to show how much will go to food, how much will go to clothing, how much goes to medical, and so on and so forth. So for those who are in that category, you're single parenting, it is important that you put your receipt in order, because what we look for is we go back to your neighbor's shopping for the last 3-4 months, and you have to show how much did you. And even these M-Pesa statements are very crucial. I leave it at that. That's so far for children. Shirley, do I move on to the next item and we ask questions later? Okay. Not in any order, but now I want to tackle matrimonial properties. Matrimonial property is property owned by spouses, and a spouse is defined as a husband and a wife. This is governed by a law that was made in 2013 called the Matrimonial Properties Act. It deals with the rights and responsibilities of spouses in relation to matrimonial property. Prior to this act of 2013, we used an old act of 1882. So matrimonial property is defined as the matrimonial home or homes. I'll explain. The couple's residence, the place you occupy and utilize as your home, is what we call matrimonial home. They could be 1, 2, or more. The household goods and effects, this will include, the ones in the matrimonial home, will include the furniture, beds, sofas, cutlery, paintings, all the things that are in that house, they are matrimonial property. Immovable and movable property, jointly owned or acquired during the subsistence of the marriage. This will include cars, shares at Kengen and the rest and titles that are jointly. So properties that you jointly own, we call them jointly owned. All properties that you hold in tenancy in common. So my secret, kuwa mzuri. Get those people to have your titles jointly owned. All tenancies in common. You won't have to have trouble when they are out of this world or when there is a matrimonial issue. Any spouse have equal status to acquire and dispose of properties. So these are not the days when women could not acquire. Any property acquired are now on properties that are separate. The separate properties include properties inherited before marriage, properties acquired before marriage, properties held in trust under customary law, and properties that you are gifted, maybe by your husband. All those will not form part of the matrimonial property. They are separate property. A matrimonial property cannot be sold or mortgaged without the consent of the other spouse. If you remember, anytime there is a loan to be taken or there is a land control board meeting, you find you must swear. The wife, if the title is in the husband's name, you swear an affidavit requires spousal consent. You may be familiar with that. So, and again, they cannot take a loan without you being involved. So the matrimonial property cannot be charged without the consent. Ownership of matrimonial property vests in the spouses according to their contribution. So prior to this law, women did not have anything. But now, if you can show contribution, and the division is according to your contribution. So what happens in case there is a divorce or you've just disagreed and you are fearing this man will sell the property? You can go to the land's office. So it's good to always have copies of those titles, copies of those certificates of ownership. Very important for every woman who is married to have them. So anytime you suspect that something would happen, he is taken in somebody else, they normally will transfer. So they transfer those properties to those women, those to Shungwa. So it's important at that point you put a caution or a caveat. You swear an affidavit. There's a format of doing it to the lad's office where the property is held, so that he cannot dispose of it. So that we've said, you can also move to court and have an injunction. It's a restraining order that restrains him from disposing of this property that he's holding in trust for you because it's matrimonial property. So I have said that. So what is contribution? Contribution means monetary and non-monetary. Thank God for this act. Monetary is the cash. So you must show how much you put to the purchase and acquisition of that property. How many times did you niongeze 200,000 and you don't even know what he's buying? It is important to be inquisitive, to follow anafanya nini na hiyo pesa, ulishukua kwa shama na ukampatia hiyo pesa, and he went buying property and then you're out of it. So it's always good to keep record, keep your bank statements, keep everything. Non-monetary includes the following: domestic work and management of the matrimonial home. So this really is a relief, because it doesn't mean because you are a housekeeper or you just a stay-home mom that you're all right. Sometimes you even have 75%. So domestic work and management of the matrimonial home. Childbirth and child care is a point. Companionship. Hii ya kutukana bwana yako. Sasa hiyo ni companionship. I've seen in cases in matrimonial, these matrimonial things, they bring even videos that uliwatukana. And the court will, companionship gives you almost 15% of the claim. So be a good person. Management of family business or property. Family business here will mean a business run for the benefit of the family by both spouses or either of you. What I would say to all of us is be a woman, or a Proverbs 31 woman. If you remember that woman, she works hard. She works hard, she buys properties, and she comes to show him. So how many will do that? Let us be women who are focused. When you run a business, whatever business, don't think of the big business. Think of whatever business you are doing in that home. It gives you points for claiming matrimonial property. I've said about a woman, a spouse may own property. That is property acquired before marriage, a gift, inherited property, trust property, customary property. And what will happen, you can do a prenuptial for those who are not married. When you are getting into a marriage, at least 21 before that marriage, you can make a prenuptial agreement. This is an agreement before the marriage, prenuptial, so that it protects your properties. And when you get into this marriage, he can never claim a trust over them. It's a mzungu thing, but it is cashing. It's being done a lot in this country. It's not a bad thing to have a prenuptial agreement. But all these properties I've called separate properties. The ones I've said acquired before marriage and all those inherited can become matrimonial properties by only one mistake. If a spouse makes an improvement to that property, the word that I used before, you must show contribution. So once you make that improvement to the property, then it becomes matrimonial property. In as much as you inherited it from your parents, in as much as you bought it before the marriage, if he improves it, then of course it becomes matrimonial property. And the sharing is to the extent of your contribution. Again, I'm just a lawyer, so I say keep all the documents of what improvement. You see, inherited properties don't become matrimonial property. But if he inherits a property and you improve, you do a home, like the one Pastor Jane was saying, you do that to go off a house on their land, it ceases to be separate property and becomes a matrimonial property because you've put a contribution. So let's tujikakamue. That's the correct one. We work hard to support this cause. Children have no claim over matrimonial property or say at all. And a spouse cannot, during the subsistence of the marriage, be evicted from a matrimonial home. Remember that one. So, you cannot be evicted. But if there was a loan, the person we call a shanji in exercise, the bank, in exercise of their power of sale, they can sell that property. If he becomes bankrupt or there is a court order, he has some debt, and the house is taken as to repay that, is sold for purposes of repaying the debt. So very important for us to know what your husbands are doing in this life, because if he is taking loans, utakuja tu kupata auctioneer hapo kwa mlango na umefukuzwa. So it's important to do that. You are not responsible for debts contracted prior to marriage. So it's important as you get into that relationship, get to know whether they have loans and the rest. What happens to matrimonial property in a polygamous relationship? In a polygamous relationship, the first wife will share the first with the husband. The second wife will share first and second and the husband. The third wife will share all of them. So if you are number 10, you can tell all of them 10 will share. So you don't, number 2 and 3 and 4 will not have a say over that property. Tutashare sisi wote. Obtaining your share is to file what we call an originating summons in the High Court. Sometimes it depends on the value of the property. If the value is up to 20 million, it goes to the High Court. And if it is not, like in Nairobi, we have a family division in the Chief Magistrate's Court, it's filed there. And the most important thing, for you to get this distribution of the property, there must be a dissolution of the marriage. There must be a dissolution, not just up halfway. So the court will expect you to have a decree absolute and the receipts showing how you contributed, have photos, have every document that can be supported. Courts also may screen these cases for mediation, and that mediation, because the two disputants are the ones who come up with a solution, the courts will respect that settlement agreement reached in that case. So before you go for a matrimonial property case, it's important you discuss with the other party. Normally they agree, and you can have a lawyer draw up an agreement which we may call a settlement agreement, or we may call it a memorandum of understanding, or you can still even have an independent mediator, provided they are professional and they'll help you through the drawing of that agreement. It's only when it's not possible that you go to court. I'm done with that. I want to look at divorce very briefly. Divorce is the dissolution of a marriage. So there must be a marriage. Remember, there are various regimes of marriage. There is the Christian, the civil, the customary, the Hindu, and the Islamic. The customary one, if you remember after the amendment, this is 2014, you must obtain a certificate of marriage within 6 months of marriages. This is the time they are coming to see your parents. It is important to know what forms to get from the registrar of marriages at Sharia House, and obtain those documents to be signed by the wazee, those who will be sitting during the negotiations. Because once 6 months are out, what I've seen with the courts is that you now want to get out of that customary marriage. Do you know the courts will dismiss that petition? They say you don't have a certificate to show you are married, so they dismiss. You are stuck in a marriage that may be abusive. So there must be evidence of marriage through a certificate. So it's also good. Sometimes when we put those certificates, I did mine 45 years ago is when I got married. I'm making 45 years this year on 30th August. And we put those certificates in somebody's pocket. And you don't know where that certificate goes. It's important to have a copy of that certificate. I'm not saying you should divorce. I know you are in Cathedral, but I'm saying it's called wisdom. So let's have copies of certificates, children's birth certificate. All those documents are very important. You cannot commence dissolution of a marriage without that certificate. Our divorce system is fault-based. So there's no divorcing by consent. You cannot agree to divorce. Somebody had tried to introduce this in the parliament, but it was found to be unconstitutional. In fact, as early as this year. So the various grounds of divorce are provided for each regime of the marriage. And because I'm sure most of us here are either Christians or Christians, that's the one we did in church. The civil marriage, the one we did at the AG's office, and customary. It's important to say, because it's a fault-finding dissolution, you need to prove acts of adultery. One or more acts of adultery committed by that other person. It's not just a story. You have to have evidence. Most of the evidence we get is a child was born. So you must have that certificate of marriage that aliza uko nje. That's a good one. Not just imagining. The physical or mental cruelty. The physical cruelty here is the person who assaults you physically and that beats you. So it's important to obtain a P3 form. We are in 2025. It's in order. If you go to any police station, there is always a gender violence police officer, and normally they are ladies. If you cannot get that, go to the women's hospital or any hospital and get yourself a medical report. That's for physical. Mental cruelty is inflicted in many ways. Those abuses, those humiliations, so you will know them. If we counted them, we will have as many as we are. There are very many. That person who just thinks you are takataka, and he calls you that, abuses you in front of children, his relatives. He can drive away and leave you walking. You ask for money, and it is slaps. So those are people who are abusive, and we say that's mental cruelty. But courts would always want to know, have you been seeing a therapist? Seeing your pastor is good enough. These pastors and pastors' wives are very important. When you go to those courts, we say we've been sitting with our pastor and we have tried and it's not working. They respect that mediation by pastors. So it's very important. Then you can have desertion, is the third one. Desertion is where immediately preceding the petition, you've been separated for 3 years. It has refused to work, and you've been separated for 3 years. The courts will give you a divorce, a decree on grounds of desertion peke yake. If he deserted you, he walked away. There are exceptional depravity as number 4. This is financial abuse, where a spouse neglects another to fully provide. And the multiple instances of adultery and cruelty, we call them exceptional depravity. We also get a lot here, because a lot of people, by the time you mumekosana, they don't want to provide. Then there's something they have introduced in 2014 called irretrievable breakdown of the marriage. And I will give you instances. This includes grounds of adultery, cruelty, and desertion. You still have to show them. But the court will also allow you to include willful neglect of the spouse for at least 2 years before filing the case. And if you've been separated for 2 years, remember I'm talking about irretrievable breakdown of the marriage. Tumeongea hiyo ma-adultery, ma-cruelty, ma-desertion, but there's a new one, that irretrievable breakdown of a marriage, where we say that there are irreconcilable differences between the couples, and most of us use this one because you don't want your children to ever read those proceedings and see their father was adulterous. So we use irretrievable breakdown of the marriage. There is also the level of antagonism between the parties. Courts will also accept that. What is the level of antagonism? So there is evidence. There is sentiment or mistreatment between the parties. The lack of concern for spouse's emotional needs and lack of commitment. I'm sure we can get that, a lot of them. Is there any chance of resuming spousal duties? And where there is no chance of the marriage working, the courts will allow on irretrievable breakdown. The same grounds will apply in customary marriage. So customary marriage, we have to go for the same. But there is also another one. If he denies you your conjugal rights, it's also a ground. So you write them down there, and the court will just give you a divorce on those. You only have to prove, all this. It's not mere suspicion. I've said about adultery. Most of the people are caught in their social media. They are caught in social media images and communication of an affair between the husband and another lady. And I had said the birth certificate of another child. The procedure, now when you've had those 3 years, but the law keeps on changing. Recently, a court said it's unconstitutional to wait for 3 years. So again, in as much the law says 3 years for you to file the petition for divorce, you can file it as soon as 2 months. I'm not encouraging, I'm just a lawyer. You can file as soon as all this has happened. So the courts are, these days, they allow you to file before the 3 years. Long time we used to file a petition to be allowed for leave to file the petition. That's what used to happen until recently. In fact, it must be an authority in this century. What will happen if this man is the sole breadwinner and has thrown you out of the matrimonial home? You can have protection by the court on the matrimonial home, not to be thrown out, you and your children. And what will happen, and you don't have money? We talked about maintenance for the children. What about yourself? There's something we call maintenance for you, for the spouse. And here I'm talking about both of them. You can maintain a husband, or a husband can maintain you. We call it alimony, maintenance. So where he has refused or neglected to provide, you can apply to court for alimony. But you need to show this is the lifestyle that he had given you. And again, documents. That shopping you do. Don't allow the man to do the shopping every day and keeps the receipts. You will not have any document to prove that there was, there will be no document to show that you need to be supported again. So keep some documents. What about where somebody has left for 7 years and you don't know where they are? There is something we call presumption of death. This is not under the divorce. It's just a point to remember. If for 7 years you don't know where that person is, you can apply to court for them to be declared dead. Maintenance orders will lapse where the petitioner or respondent dies, or where one is able to support themselves. That is now the alimony, and upon remarriage. So when you remarry, a lot will happen. When you remarry, you cease to be supported. When you remarry, in succession, which I'm covering shortly, you cease to be covered by, and you must return all those properties to the children and to the family. The procedure is we file them electronically. A notice of appearance is given by the court, and within 15 days, you have to serve the other party. The other party is given the time to file an answer, and they may file what we call a cross petition. What they normally do, they will always file, they will also ask either for divorce, or they'll cater with the divorce, and they'll file to say, you are the one who was adulterous, you're the one who did all the things that I talked about. So in the cross petition, and then it becomes a whole case. In the answer to petition, that's the one now, they can answer. Now they answer to defend or to canusha what you have said, but they can also add what you have also done. All of you are supposed to file documents at the beginning. So any document you require for support, the marriage certificate, children's documents, all those, and the receipts that I'm talking about to show this is the status of life that he gave you are supposed to be filed at the beginning of the case. What do courts do? Courts hear this in camera. Although these days, because of virtual hearing, you'll find that some courts will chase everybody and still hear you, even if it's virtual. We call it in camera. But courts are not interested because we file what we call a petition, a witness statement. Courts will ask you to adopt the document. So you don't have to say all those things. But of course, if the other advocate for the defendant, the respondent, will ask you questions, then the world will be hearing because it's in open. So after the divorce and a judgment is issued, there's what we call a decree nisi. And then after 30 days, it is made absolute. Remember, that was the document that I talked about that we'll need when we have to go for matrimonial property. Last item. I want to touch on when there is a loss of a loved one. We call it succession. The Succession Act is Cap 160. It was enacted in 1981. It has not changed. In this one, you can have testamentary. Testamentary is when you make a will. All people die testate. People die intestate. So testate is where you have made the will, and intestate is where you did not make a will. We encourage people. It doesn't matter your age. I think I made mine when I was 25. You're not dying. You're just being careful. So it's important to make wills, encourage your parents, encourage family, because these succession cases that you see, like the famous one for Koinange Bio, that stayed for over 40 years. It was finalized, but I think there are still applications after applications. Now, who will ever gain that? The wives will never get it, and the children, maybe it will go to grandchildren. So it's important to make wills, encourage people who can make a will. A will is made by one who is of sound mind, over 18, and who has personal property to distribute. When you make a will, you have to appoint somebody we call an executor, stroke trustee. When you are not there, who will take charge of the properties that you owned? So those are called trustees. Number 2, it has to be signed by 2 witnesses in the presence of the testator. The testator is the one making the will. So there must be those 3 people at the same time. In fact, it says signed by the 3 of us at the same time. Now, courts will honor that. Courts will honor wills that were signed. Don't let your people sign when mzee ako hospitali hata hajijui. The other side, or your relatives or somebody in the family will file an application to contest the will, because you can't have it made when he's not of sound mind or when he is too sick to know what he's doing. So it's important that wills are made when you are still young. Then I realized that old people, they can be swayed. Once your parents are 80, they will love the person who gives money. So if they had made a will when they were in their 50s, and now you are the one who is giving more money, or you are visiting them, and they are siblings who are very biased, they make sure that they start visiting those parents in their sunset days, and they want to, I'm looking for the right word, they want to be seen to be the best. In our language we say they really come and they show this father that they are the best. They would rather even take a loan. Be careful of such people. So it's only the free property of a deceased person. They can include properties like the titles. They can include shares, Kengen, and the rest. They can include businesses that they own with other people, properties that they co-own with others. All that can be included in the will. And anybody can be appointed. They can appoint a relative, a wife, a child, a friend, pastors. A lot of people use their pastors to witness, doctors and lawyers, and etc. If a deceased dies without making a will, the order of the person who apprised to court is the surviving spouse. If not there, the adult children. If not there, the parents of the deceased. If they are not there, the brothers and sisters. If they are not there, the public trustee may make the petition for what we call grant for letters of administration. And even a creditor. When there are creditors in your family and you don't pay them off, they can get into your parents' estate and they file that petition themselves. They pay themselves first, and then whatever is left is for the family. So I've talked about the two. When there is an intestate, there must be two representatives, the people we call sureties. Those sureties must be there. A petition cannot be made by more than 4 people. And even if it's a polygamous family, you can get a representative from every family. People of unsound mind and bankrupt people and minors cannot be appointed personal representatives. The way to apply is to start with the ID. Once somebody passes on, they have an ID. You'll remember to obtain from Huduma Center the death certificate. That will never be issued without the original certificate or the deceased ID. If a person dies abroad, you must register the death in Kenya to obtain a Kenyan death certificate. If it's a will, you must have the original will, and it must be read immediately after that person has passed on. So the original will have been read to the family upon demise. There must be a chief's letter. The local chief of the last place of residence of the deceased must be there. This letter introduces the family to the court. So you'll find it is written to a particular court. You'll be required to have copies of the titles and the sashes. You'll be required to have logbooks if there are cars, share certificate, bank account details, CDSC accounts, bank statements, CR12s if it's a company that is limited where he has shares. I've said only free property of the deceased will apply in both cases. How to petition their forms. So anytime you are applying, you'll be assisted. There are normally probate courts in almost every county, and the jurisdiction is 20 million for cases in the High Court. So the property that you now have listed down, you'll have to evaluate. So there's an affidavit in support that shows the property, the value of each property, so that the courts, you decide which court to go to. Once the matter is placed before the registrar or the magistrate, it's advertised in the Kenya Gazette. A Kenya Gazette is, I'm sure you're familiar with the Kenya Gazette. It has to be there so that if this person had another family, normally another family, they will file an objection. So it is placed for 30 days, and if within 30 days of the gazettement there is no objection, then the courts will issue a grant. If there is an objection, then the process is now hearing the objection, because people will object. Maybe he had another family and they were left out. If it is a will and there is an objection on a will, the witnesses who are the witnesses to the will now be the ones to be called in to produce evidence that indeed that man sick as to know what he was doing. So we call it propounding the will. So the court will allow you to first be heard on the validity of the will. And this happens so many times. The police may be involved, but the police have nothing to do with it. What we will normally do, if it's a question of the signature, And that's why it's important. People make wills when they are not too old that they can't sign. If you are signing and then you are now doing a rub stamp, then there'll be, the court may not take it. But what we do, we ask an examiner, a handwriting examiner, to help us to clarify or to examine the signatures to see if they are forgery. So if the court then finds the person who signed was not of age, the witnesses were not even there, the court will just reject the will, and the matter will go back to intestate. Where the will was done through fraud, forgery, mistake, coercion, undue influence, or there are suspicious circumstances as to how that some people do this. When the mzee is very sick, maybe with cancer, those wives, if there are many, one of them goes early in the morning, colludes with the doctor, and they make a will. So if there is coercion, if the person did not understand, if there is a mistake, there is undue influence, and suspicious circumstances, like what I've said, the courts will throw out that will. So we say it does not meet the legal requirements of a valid will at the threshold, the legal requirement. So if a will leaves out a beneficiary, it is not always a case for throwing out a will, because the court can still provide through the properties that have been left. You may ask, if you make a will at this age and then you get many other properties, we do a lot of annexures, we call them codicils. So you can make a will, or your parents can make a will, and then they sell part of the property, or one of the people they had given passes on, or circumstances change. So we can always do an addendum, an addition to that document in a form of a document, or we do a codicil, which is a document signed in the same way as the original document, and it is attached to that will. So where do we keep these wills? We normally keep the wills with the advocates, and it's bound in a way that in my office, we normally register wills under the RAD's office, the documents division. So it's a complete document. Then you put it in a bahasha, and the testator signs all corners. So the day of opening, the signatures are all over. That will, nobody can contest it. So it's important where you put it. Most of the clients will insist on taking the will to the bank. That's also okay. But never take it to your house or leave it with your friends, because it will wreak. So when you are reading out the will, everybody who is interested, even uncles may not be beneficiaries, but they can be invited for order. And take minutes, because when people go to court, they are like, when was the will read? So there should be minutes to show the will was actually read. What happens after a grant has been issued, what we call grant of probate, or grant of letters of administration in an intestate matter? Once that is done, nobody objected, you can now file summons to confirm. What does that mean? Summons to confirm the grant, now you are now telling the court, I have put together, now you, the administrator, or the person now, the trustee, you are now supposed, when you started this case, you are supposed to correct in all the properties belonging to the deceased. So now you have put in everything that belongs to the deceased, and you can ask the court to allow for distribution. So the summons for confirmation are now for distribution of whatever was left in the will, or whatever you have corrected in the intestate. So 6 months after we filed the summons, we also indicate in an affidavit the mode of distribution, and there must be a consent signed by all the parties, all the beneficiaries. So again, when the affidavit showing how the mode of distribution is done, every member of that family will sign to say they have seen this, and that is it. And at the hearing, courts will ask each one of you, maybe some of you have gone to those courts. They ask you, is this, maybe some of you have gone to those courts. They ask you, is this, you must show your ID, even if you are abroad, you must attend that confirmation. So you show your ID, you confirm that is an estate you are familiar with, and whether you've agreed on the mode of distribution. So that is very important for us to show that mode of distribution. And then the court will then allow for the distribution according to the proposal that you have given. What about if the will was made and you find some less injury? So whatever properties you find after the will was made, during the confirmation, you bring it out and the court will distribute it at that point. In that will, we also talk about what will happen to you. Many people write, I want to have a service at Cathedral of Praise. Others will write, I want to be cremated. I want to be buried next to my husband. You write all that. What do you want? Some say, so you can write all that in a will, and there's a lot of cremation. Others say, I want my body to be given to Shilomo for standing, and so on and so forth. So the court will honor your wishes. It's all about honoring your wishes. And let me tell you, courts will rarely draw a will out because it's the wishes of the deceased, and if they signed it with all that I said, the details that I talked about, then the court will honor that will, and the property will be distributed accordingly. Should there be somebody unhappy with the proposal on the distribution, they file what we call an affidavit of protest. The one that we filed after the gazettement is an objection. The one that we are filing, because you are not happy with the proposed distribution, it's called a protest. And then the court will expect you in your own affidavit to file what is your suggestion on the distribution. This only applies if there is it's an intestate. Because you remember in the will, he has already said how he wants it distributed. So courts will then hear this matter and make a final determination. And you'll find this is what delays cases in the courts. Other than those grants, now the main grant, the grant of probate and grant of letters of administration, in the intestate situation, there are other grants that can be issued. Remember when we said that a child who loses their parent, the surviving parent can move to court and obtain maintenance from the property of the deceased. So at this point, you can obtain a special grant, what we call limited grant, to get to a succession case and get your child's the school fees, because most of the bank accounts are frozen upon the demise of somebody. So you'll be expected to file that application in the succession case. It's an urgent application, and court, remember then you'll have to have the fee structure, the amount of money you need for food, for medical, for all that, and the court will give you, will tell the bank to release so much fund for school fees and so much fund, so much money for whatever else you need. So that's for reasonable provision. You can also have for reasonable provision. A wife can also apply for that reasonable provision through that limited grant. A limited grant can also be used when the spouse was having a court case going on. If a court case was going on, you need to substitute that person. And you cannot do it unless you are a personal representative. A personal representative is that person who holds the grant. So you need to hold the grant. So the court will allow you to have a limited grant to be able to continue with the case. If you do not do that, then the case is said to abate. So imagine you have been following a case, for your father, for whoever, and then you make one mistake, the year goes, you've not substituted that person who died, that case abates. It doesn't matter what the value of the case would be. So it's important upon the demise of somebody to know if they had cases pending, so that you get into those cases. The personal representative gets into those cases as soon as possible. When does a public trustee become an administrator? I said when there is no one applying, or when an estate remains administered for 6 months. So it's always important upon the demise of a family, you accept, you adjust, and you advance. In the advancing stage is where now you apply for the succession. Because if you don't do that, and this person had a pension, then that pension will not be released. And it's very important to remember that. There is one other area. Properties that do not form part of the estate. Whether it's in the will or in the intestate, property held by the deceased as joint tenant. When you hold a property jointly with the other person, normally spouses, upon the demise of the person, you only have to produce the death certificate at RAD's office and the property becomes yours. Joint proprietorship. Joint. Very dangerous, sometimes very good for the women. Because if you are jointly owned with somebody and they passes on, remember I'm just a lawyer, I'm not saying they die, you will have a very simple way of getting that property to yourself. The other property are joint bank accounts. If you own joint accounts jointly with the other person, they cannot claim them. So those ones now remain for the surviving. Pension schemes. Most pension schemes you have the next of kin. Those are discretionary pension schemes. There are other things like gifts and life assurance policy. Life assurance policy will normally dictate what happens upon the demise. So in life insurances, and I had a very sad one recently, my client's son died during COVID, and unknown to the father was the named beneficiary in more than 25 million assurance policy. Unknown to the father, this man seems to have changed when he married, just like 2 years to the death. And so the father did not believe it, and we had to ask a forensic person, an examiner of handwriting, to help us. And we got to know that it was a forgery. So what this person did, immediately the husband died, they knew the beneficiary was the father. They went, colluded with the people at the life assurance policy, life assurance company, and they got the names changed. We are still in court, so we don't discuss things that are still in court. But I'm saying it is important for life assurance, if you take out one, let you know who is the next of kin. Name the next of kin properly. It doesn't have to be your husband. It can be your child. And the court will honor that. Assets of a company. Sometimes a limited liability company it may own property. So you own property together with others, not necessarily family or the spouse. And so what the courts will do, you cannot include, most of the companies will have a clause in their memorandum and articles of association as to what happens upon death. So you find that some of them will say that their share will have to be retained in the company. So if it's only the shareholders of that company that can own it, then it can't be included in the succession. But if it doesn't say, then you can include it, just that share. It can be included there. A wife and a child left out, I have said, may apply for provision, for reasonable provision. So even as the course goes on, and in the middle of it, you realize that you need provision, you can apply within that course. The one I talked of, in an interim grant or specific grant, is when you've not started the process. But if you've started the process and you still want provision for the children and for yourself, this time it's not ceremony, it's a provision. You can apply to the court under one of the rules. What are the rights of a surviving spouse? A surviving spouse has no rights to the estate other than the dependency. So when the surviving spouse is left, she's only entitled to personal and household effects, that is clothing, articles of personal use, furniture, utensils, appliances, pictures, ornaments, and so on, absolutely. Chattels, and only entitled to a life interest on the other assets. So all those titles, you only have a life interest. Life interest, meaning you can only hold it for your life. Once you are gone, it reverts to the children. Unfortunately, courts have been very, the courts are different. You find this is applied by a court in Garissa, a court in Mombasa, in Nyeri, a court in Nairobi will say, is this what you people have agreed? You want your mother to hold all the properties? She can be allowed to hold all the properties. It depends on what you agree at the time of the distribution. And most children will say, as long as mom is alive, let us respect her, let her continue holding the property. Unfortunately, a few mothers are left with these properties and they remarry. Others, they sell. If that your mother remarries, the properties must revert to the family. If that mother starts abusing the property she was left with, starts apportioning it to those favorites, then you must move to court to stop her. And it is in order for you to stop, because if you allow her to give all the properties she got from your father to only a few, then what will happen to the others? And I see that all the time. That's why we are forever in the courts. Because mothers, they get, instead of getting a life interest like the law says, they get an absolute. And even this wakili normally says the mother to get absolute. Because what has happened, the family came and said, maybe they are young people, they are in their 20s, or they have their own properties. They normally say, let mom keep everything. Atatupatia at her own time. So there's the danger. The law doesn't say she gets more than the life interest, and it is important that we are mature. Everything else then belongs to the children once the life interest is over. The rights of the child during the division of the property is that they should be equal. You cannot give sons and daughters differently. The law recognizes the child as the female and the male. I know a lot of the customs here, they don't allow daughters to inherit at home. I know I'm talking to myself. They don't. And if your father is giving anything, they give 2 acres, your brother gets 20. So if he gives during his lifetime, it's okay, we honor. But if it is after his demise, we fight for it. It should be equal. It should be equal. The only thing I see... The only thing I see them doing is that you don't leave your husband's home now and you go back to where you come from. But I know a few Kikuyus do that. They move back to their father's homes and they jenga that place, and they were married in Kisumu. So that I don't understand. But because it is equal, you can also inherit that one. There is no objection. Eh? What about the children born out of wedlock? Is there a difference between the child born out of wedlock or the child born in a marriage? No. The children, not even born out of wedlock, if your father adopts a child and maintains that child can move the court under that section of dependency to say, I have been maintained by this person and I am entitled to share. So you find a lot of those cases in our courts where you are not really related, but they adopted you. Not through court, but they've taken care of you since you are young. So you become an inheritor in that family. The child born out of wedlock, also inherits. That's why you find when these cases are filed, the objections are very many. Or even at the time of the funeral, you find so many women in the same attire like the widow, because they were not honest. So you find they have 3 other families. So all that is sorted out through DNA and the rest. And that is done all the time. So adopted children inherit. So the topic we didn't handle. So there's a presumption that if one is born in the course of a valid marriage or within 280 days after dissolution of a marriage, that child is the deceased child. 280 days even after the dissolution of the marriage. So you can't remove them from there. But DNA is everything. A child taken by the deceased and accepted and treated as the child, his own, that's what I said, an adopted child. Once adoption is done, and we may not cover that, once you want to adopt a child, you don't have one or you just want to add into your group to many children, there's a procedure of adoption. International adoptions have a moratorium because it was abused, but the adoption here in Kenya is continuous. It's such a rigorous process. It needs a lot of consent. So if one is interested, you can always ask me. But an adopted child, once the adoption process is over, they get a proper birth certificate like your own. So that adopted child becomes a beneficiary. Grandchildren will not have an immediate entitlement, but if the parent of that child is dead, then that child inherits to the extent of that parent's inheritance. So the grandchild or the grandchildren of that particular child inherits to that extent. Other relatives, if a deceased is survived by a spouse and they had no children, the spouse will inherit. Other relatives only access the estate through an application for reasonable provisions. I've seen parents apply. Instead of waiting for your in-laws to apply, it might be just in order to include them in the process. I have cases where somebody dies, you are left, you don't even have a child, and you don't want those in-laws to inherit. It's very unfortunate. You want everything to yourself. But courts will give parents part of the estate. So what the law says is that there was an expectation. A parent expects to be taken care of in old age. So when you are old, if a child dies ahead of you, then that parent is taken care of because there is that expectation that a child takes care of their parents in old age. If one commits murder, kills the deceased, they are barred on public policy from benefiting. When it is time to distribute the property in a polygamous situation, what happens here, we take the first wife, has the first spouse, the first wife is there. Only in polygamous, the first wife is there, 2 children. The second wife is there, 4 children. We call them units. So when we are distributing, if you have 5 children and yourself, you have 6 units. If you have only Kamonja, then you get only you and that Kamonja. So your unit will be 2. That's how the polygamous, in a polygamous situation, that's how we distribute the estate. Who is recognized as a wife for purposes of intestacy? The Marriage Act indicates a wife is that one who holds a marriage certificate, we've just said. The Act implies that if one marries in a civil union or Christian union, which are monogamous in nature, after the man marries in a polygamous union, the marriage will not be recognized. This is very careful. We've done very many cases where you find the first wife was married in church. Then analeta mwingine anapreted customary, where you have no say, but your children will inherit. That is in the marriage. Lakini the Succession Act allows a wife to be recognized. So we must understand, in a marriage, you are not recognized. The Succession Act allows that wife to be recognized, whether through civil Christian or after polygamous marriage. There is a section that was amended recently, not very recently, section 3.5, and it is not interesting. Not interesting. Some courts may also consider presumption of marriage in determining whether one is a wife. This presumption of marriage arises where parties have lived together for a long time. Parties have the legal right or capacity to marry. They must be over 18 and they are not married elsewhere. Parties have intended to marry and they must have consented. Parties must have held themselves outside, to the outside world, as married couple. So they normally call their neighbors to say they are married. The standard of proof, what we say, standard of proof, how can you prove that? You just have to bring people to say that in succession matters. Courts, however, after the enactment of the Marriage Act, indicate that the presumption of marriage is on its deathbed based on marriage laws. But remember, courts rule differently. You may find, when you go looking for a particular topic in the laws of Kenya, you'll find that one court may adopt the presumption of marriage wife, or another court will say it doesn't apply. So do you think a cohabitee or a mistress is recognized? No, that one has no right to inherit. But if they come with a child and the DNA shows it is, very important. Again, the succession cases are screened for court-annexed mediation, and parties are sent to a mediator, and most of them are handled there. But this, you cannot have mediation and complete the process because you need the grant, you need the court to determine the distribution and the rest. Thank you for listening.
Thank you so much, Wakili. We are now learned friends. Tutakuomba, we request that you take a few questions just before we go for lunch. Mrs. Kirubi, please. We passed papers around here. Kama umeandika maswali yako, we may not be able to answer all the questions, but Wakili will be around. Hata kesho atakuwa kanisani, unaweza mtafuta. She has, unaona ako na tabia mzuri, hata hajajitangaza. She has an office, she has a law firm. Iko wapi, ma'am?
It's at Law Plaza, Kilimani.
Law Plaza, Kilimani.
Law Plaza, Kilimani. I know she wants to say I work with my 3 daughters. All my daughters are advocates. Can't say my bishop. He out. It can give you what you want.
Amen. So, na akona twins. Na ndio hao advocates. Amen. So hiyo nyumba, imagine wanaongeanga tu law. Proceed.
Okay. We have very many questions that have been brought. My name is Julia Kirubi and I'm born again. I serve in here. So I think I will read the ones that she will be able to answer. And then if you have a question and you want to ask without writing, it's still okay. So I go to question number 1. Is it allowed to oppose a will where the primary owner is deceased? If yes, where is the process? How long does the case take?
Yes, we said you can oppose the will. If you suspect that the will was not made by the person, the deceased, you can oppose. And at what point? Immediately it's gazetted, those 30 days, because even that one is gazetted. The petition for probate is gazetted the same way. So once it's in the Kenya Gazette, you file an objection. And in your objection, you'll be saying, it's not true he left. If the people who are said to have signed were not even there, or they had no capacity to sign, again, you can challenge that will. It's what I called, I don't know if I said, validating the will or impounding the will. So you can also bring in, if it's a forged signature, you can ask for a forensic person, an expert of handwritings, to give you an expert report, and you can challenge it on the basis of expert advice. Does that answer?
Okay. Maybe to add on that, Madam PM, do we have a guideline on the composition of those people witnessing? Can I witness and I'm a beneficiary?
It's not fair, just in case there will be, remember you as a family, you may be very close. Some families even tell their children, most of my clients will make a will, then they have various titles. Then they write at the back and they give those children the titles. Then they tell them, when I'm not there, go to PM's office. So they come with the titles, and that's very easy. But remember, there could be another family. That's the difference.
Okay. Thank you. Another question, still on the will. I think hiyo ndio imewaguza sana. It's a scenario. Husband dies and he writes his 2 wives as next of kin. But before burial, another woman emerges and wants her children to be included in the eulogy. But later, she is using the eulogy to claim the share of the benefit. Does she qualify the benefits even though she's not recorded as next of kin?
Yes, if she was a wife, remember there is the polygamous situation. So if these 2 wives are recognized in the will, and the third one and was a wife and has children was not recognized, they can still file an objection once the matter is gazetted, and the court will listen to that. Matters of eulogy, matters of newspapers, what most women who are busybodies, they will even do the eulogy. They'll come. You see, it's not the family that does that eulogy. It's done by friends or the committee members. So they normally will influence somebody to add their names. That is not a qualification. The court will then listen to how are you married, how long did you live with this person, do you have these children with this person. And most of the people, when they see an old man and about to go, they will insist on living with that. So now Namzee, I'm a short one, is no longer in the first 2 houses, I'm a short one at the third one, and they transfer most of the properties to that person. And it's very hard to get those properties back. Those are the various cases we have, because this woman is coming with an heir. So she will get children with this person, because you only qualify if you have children with this person. So you find they have children with that person, and they will get into this succession and may get more because they got him at some point and they have had most of the properties transmitted to them. But I would say this, when you are distributing the estate, whether it is intestate or testate, the court will consider what we call gifts during the lifetime. So at the time of distributing, the court will look at, you had been given a house in Luda, so that is one. So tunakupea hiyo. Then we go to the next person. So we give you an equivalent of the Ruda home like that. So if you have gifts intervivals, gifts before the death, they are considered during the distribution.
All right. Another question. In case of property bought during marriage but alone, I buy a property alone without the help from a spouse. Can you have your children inherit the property and not their father? What can be done to prepare for that? Oh, mama wako na property from Chamas.
I know. The property bought during marriage, we call it property acquired during the marriage. We talked about matrimonial property. So if this person has contributed to its improvement, you bought a property at Kamulu, then you said, babes, let me show you. And then he comes. Remember, he is also being told by the lawyer what to do. So he puts in an improvement. He puts in some rentals. Now, when you are not there, he will recover the contribution, and your children can only take your share. So he will file an application for his entitlement first, and then the court will distribute the remainder, which is yours, like we were in a matrimonial property case. You understand?
Okay. Another question, the final one. My daughter-in-law is a drug addict, drunkard, and is beating her children after divorce with my son. I've taken the children under me. I have OB at police station. I've gone to children's department. I've got a lawyer. Next is Isomeki. Is it okay? Age 12 and 9. I want custodian of the children.
When the other parent is alive, the shosho may not get custody. Unless they are all drug addicts, when I say a guardian. So the shosho can come in as a guardian and apply for custody. But to avoid the children's court in form of shosho coming in as to apply as a parent, the best way is to apply under guardianship. Because the husband can give consent for her to be the guardian. So the guardian now, she can now be allowed under the guardianship law to take care of the child. So my advice is she doesn't go for custody per se. She goes as a guardian. But where is this father? If the father is able to take care, the father can take care of the children. They are only 12 and 9. But in case, because if you go for custody, the courts will find you abusively. So they will not allow you, the shosho, to have custody when there is a surviving parent. But it is the exceptional circumstance of the drug addiction and the bad behavior. She's not able to take care of herself. I didn't talk about exceptional circumstances that may deny you custody. One of them is that one. I think I touched the one that you marry an abuser. You know, you go living with an abuser, the court will not give you that custody. So I hope that is clear. You can go for guardianship. And guardianship doesn't give you a lot of rights. It just gives you the right to take care of the child. There is a new amendment where you can even find a child along this street, go to the nearest police station, and the police station can write a recommendation that you go to court, and the court will give you the fostering powers. So even that can be done if both parents are absent in they are not able to take care of the children.
All right. Any other burning question? How many have you given us? All right.
Oh, thank you. My question is, can someone have more than one will? And in the sense that maybe you are not married, you have properties, you have your will. Then you meet someone you marry, you also have his will. Then you acquire properties together, you get children. Mtakuwa na joined will. Na kama kuna joined will, suppose mmoja amekufa, mtangoja mpaka huyu mwingine akufe is when it will be read, or how?
Thank you. You can't
I think PM utaanza na kuansa, when should a will be read? Tunagoja tu watu wakufe ndio isomwe.
Yes, you can't lead a will. A will is read
that
when...
is her last question. Sindio umeuliza?
You only lead a will when the person is dead.
Yeah.
But you cannot, I understand what you're saying. You remarry and you have a joint will. You can't have a joint will. I have such a situation where my client is Kenyan, married a Nigerian, and the Nigerian had a family. And the Kenyan lady had a family, had her two daughters. What we did, we made wills at the same time. the man took care of the family in Nigeria, and we took care of the will for the lady in Kenya, because there's also the problem of jurisdiction. You may find that when you make a will and your properties are spread out, like I have one for my clients, Mom, the man who helped us with the school. His properties are all over in UK, everywhere. Once I got the administration, I have to go to those courts through other lawyers to register the probate in Kenya so that I'm able to access those properties. That was not your question. So you cannot make two wills. What you do, you make the first one, and then you do a codicil, the addendum. You see, you are married, and then you have added properties, so you can add those properties in form of an addendum. The other way to handle your property is when you remarry, you have to come to this home carefree with a prenuptial. The prenuptial will dictate, these are my properties, and this you cannot touch them in the matrimonial property law. So you can take care of them through a prenuptial, through a memorandum of understanding, and the courts will honor that. Once the two of you are married, and make different wills. It doesn't matter who. If you own the property jointly, even when you own property jointly, you cannot make the will. Remember, we said that property is not available for distribution under the will, because that property is to be left with the other person. So if it is jointly owned by you and a husband, then whoever goes first leaves to the other, because it's a jointly owned property. Does that answer? Thank you.
Okay, thank you very much, Council, for the good teachings. My question is, there are instances whereby civil servants indicate their fathers, their parents, or their brothers as next of kin. When they die, what happens to the legal wife and the children? It is a trend.
Mumeandika wazazi wenyu?
I don't want to talk. I think I said pension is not part of the succession. It is governed by whoever is written there. So if he has written the parents as the next of kin, when the pension is being distributed and he has left out his children, the whole of the pension is done through, I think, the county office, the county commissioner's office. It doesn't have to necessarily, it doesn't go through the succession. So what will happen is that if you've left out your children, then of course they will have to be brought in a way. And if you've left out your wife, they'll have to be brought in. But the initial next of kin will also be considered. Only that the person paying the pension will have to consider that the children cannot be left out. But it is important that husbands also be reminded, even if you don't like that woman, it's good to write your children as next of kin and your wife.
Thank you, PM, for enlightening us for this forum. Some of us have been here and you've been teaching us, and some of your teachings has made us to be or to go in the courts and win the cases. That is why I could say that when I was old, I could have wanted to be a lawyer, but since I'm young, I cannot be one, because I would admire to be like you when I'm old. Now, my question is, there's these three ladies, wake wenza, watatu. And their husband died when the other one just came in and had 2 children. The last one, there are 3. So the first one, alingangania tu nyumba moja. But the third one akona ploti ziliachwa ploti 4, and then one akabadilisha jina yake. Now the third one naye akogishagi. Initially when the husband was getting married, alikuja kamleta yule, unaona Kijaluo lazima mwanamke aingizwe kwa hiyo nyumba ndio the others can come in, ndio wanaweza kulala kwa hiyo nyumba, wale wanafuata kimila. So now kesi wakapeleka kesi kotini, the first wife, that she needs to be divided the properties. The third wife tayari akaenda akabadilisha one of the shambas kwa jina yake. Walipoenda kotini wakapewa nafasi kwamba they go sit down, talk to each other so that wanaweza kufanya nini, kugawanya ile mali. Walishindwa mara ya kwanza, walishindwa mara ya 3, walishindwa mara ya 4, mara ya 5. Sasa hivi ni mimi wananiita niende nikawasaidie vile wanavyoweza kugawanya ile mali. So you will help me there, but I'll come personally and see you about this, because vile nimesikia baba ni mediator na wewe, then I have people who are going to help me. May the Lord bless us all.
Amen. But my answer to that would be the one that transferred the property upon the death of that husband. That transfer is irregular, it's illegal, it's void for any purpose. So the court will just do that. The court will just, I've seen this in many cases where grandchildren are named after, in my custom, they are named after the Guka. So I've seen cases where that grandchild uses that name to transfer property to themselves. And courts have no difficulty just cancelling. They send it back to the registrar and say, cancel that title, because you cannot transfer a deceased person's property without grant of letters of administration and a certificate of confirmation of that grant. So it is that certificate that we take to the land registry with a form we call Form 39 and Form 42. So they must be accompanied by the certificate of confirmation. It's the judge who says the property known as this to go to Aris. So if the judge has not, if the certificate does not show origin transfer here, that is an non-starter. It will be thrown off. And it's a forgery. You can also have yourself having problems with a criminal court.
All right. Tufikishe hapo. All right.
Thank you so much.
When we open our bank accounts, there is that space for next of kin. So we normally write the next of kin. But then, as time progresses, okay, maybe in an instance when that person, the account holder, before the account holder passes on, is there something that we need to go and do in that bank and name somebody maybe as a beneficiary, or automatically if I die? And you know I'm not dying soon, eh? Automatically it, of course she said it will be frozen. Will it automatically go to the next of kin, or I should have signed something to indicate somebody as a beneficiary?
For bank accounts, even that next of kin is just administrative. Once the person dies, the holder of the account dies, it's frozen. But if it's a joint account, we own it, the two, then the other person continues. But if it's just a mandate, some husbands will give you a mandate. Once they are dead, then that mandate inaisha. The other thing that is important is a power of attorney. People give you a power of attorney that you can do all this. Mothers give, you can do this for me, a power of attorney, power to do. They donate power for you to even sign titles, go to the bank and all, particularly people who are living abroad. The minute that person dies, the power ceases. So it's only as long as that person is alive. So it's important to have your separate account, or if it's a joint account, because it can go on, But if it is his account, it will be hard for that next of kin doesn't help in succession matters.
Okay.